Yes, Mr. Hawk. Hmm? Acha, okay, 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 okay. Item 11, both sides are represented. List this matter before any other bench without one of us. Within bracket, Honorable Mr. Justice A.M. Rita. Applies.
Item 1 for admission, WPC Sumoto 2/18.
Already Malana friend appearing on behalf of Amina.
No.
Minara.
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 The respondent one. I am appearing for the respondent one, Lordship.
The last order, my lord. Your lordship kindly see the last order.
Yes.
Last order person. Last order person. As per the last order, my lord, it will be because they said that in the writ appeal that there is a revision, there is a review pending. But practically they found that there is no review pending. So now this has to be heard in merit. So two conflicting judgment. So in such situation, my earlier occasion, there is the order passed by the Honorable Court. So I'll place this, my lord. Take the deduction. Take the deduction. Earlier such situation, my lord, what this Honorable Court done, my lord? I have placed two judgment, my lord. One judgment, my lord.
I'm sending you this.
This is the judgment.
I'm sending you this order. I'm sending you this order. Like, please see.
My lord.
Let,
Like,
let no.
next page. You have it listed before some other bench.
Oh.
My lord.
It's not here. Outside is present.
Yeah. Yeah, okay. No order, totally. My lord.
But you'll just see in the meantime this order. Oh, yes, this is what we wanted.
Yes. So let me keep a part of the.
Keep it there.
Oh, my lord, and then the
Easier.
my lord.
Easier when you
My lord.
give it.
Bibliop.
Obligers.
Item 2
Also, the interim order starts at page 33, my lord.
Where is your written statement?
It is statement also will find at page 31, my lord.
Who is Rosna Ali?
Roshna Ali is the grandfather, my lord. Roshan Ali, alias Roshan. In this case, my lord, petitioner mother also adduced her evidence as DW2, my lord. And petitioner and her mother name is appeared in 1970 voter list, my lord. At page 21, my lord.
And which page is your evidence on affidavit?
My lord, I have not annexed the evidence on affidavit, my lord, that is in LCR, my lord. DW2, my lord.
You think it doesn't help you? The.
No, my lord, I am not going to, but then my lord may fix a short date, my lord, I will, in the meantime, I will-
No, no short date, because in your cross-examination, your case is absolutely demolished.
my lord, the mother of the petitioner has given
It
this,
doesn't help it.
and my lord, her name is appeared in voter list of 1970, my lord, at page 21, my lord.
It doesn't help you. That's why we said.
See, I asked my lord that there was no time, my lord.
My court master refused you.
No, my
No,
lord,
he doesn't
you
refuse. At least
said
in
that the
this-
court is going to be sit, my lord, I asked.
No, that's okay.
Yeah,
At
my lord,
10:30,
it's my fault, yes, I am.
At
admitting.
exactly 10:30, if you want your attention, then the court master will not give it to you.
Definitely, my lord, this is my fault.
Come 10 minutes early.
Then my lord will fix a short date, man, I will go through the reports, my lord.
Because we have read it now. Mr. Sharma, and you please both read it together. The cross examination I have flagged it at page 100.
My lord, her father and mother documents were voter list details. My lord, she is studied up to class 7, my lord. She perhaps could not understand, my lord. She is not an literate person, my lord. Only up to 7, my lord. Her mother also deposed her, my lord, in her favor, my lord. And her name is appeared in voter list of 1970, my lord. And she appeared, my lord. And she deposed in her favor, my lord. That is at page 109, my lord. My lord, in sometimes, my lord, documents has been given, my lord. Perhaps there is a procedural lapse, my lord, that can be understood, my lord, but with her mother name is voter list of 1970, my lord, and she herself appeared, my lord, and deposed in her favor, my lord. And there is a patra length that page, my lord, 29, my lord.
No.
Because, my lord, there is a lack of suggestions, my lord, trial court, my lord. The problem is there, my lord. Because it is very much there, my lord. They have not, should not obtain, my lord. It is 21, my lord. Her mother name is there, my lord. That is, yes, my lord, but her name definitely is there, my lord. Some suggestions. And it is,
This is a document which is not admissible.
This was settled long time back by this court. And now it's not as disability. Still, we keep on nothing on that.
because there is a procedural lapse, my lord, in the trial court, my lord, there. They might not have given the suggestion.
There are labs on whose part?
It's our part.
It's not the tribunal's part.
Yes, my lord.
So that cannot be a procedural lapse. That's a defective evidence given. When we say, when you say procedural lapse, it means the lapse on part of the court
No, my lord,
or
no,
the tribunal
not,
to
not
conduct
my
the
lord.
proceedings.
Our father was working at my lord, Devapani Tea State, my lord.
That
Certificate.
document is also not proved by calling for the
Yes,
records.
my lord, that is,
You, in your evidence, say, I did not, never saw my grandfather. And then you say, I was 8 years old when my grandfather died.
no, his father was dead, my lord. When she was 8 years, my lord, her father was dead. In 1985, my lord. It is there, my lord. See. And it's page 24, there is a certificate also, my lord, issued by the death certificate, my lord, manager of the Devapani Tea Estate. He was employee of that tea estate, my lord.
Those are not proof.
That, my lord, that.
And you're giving a document, submitting a document doesn't help if it is not proof as per law. Does it help? Giving a document.
Remanded the matter, my lord, and
Can be given.
one opportunity may be given, my lord, for that.
Any kind of document can be given by any.
You see, in 1985, computer printout was not available. Page
No, my lord, it was issued on 2016, my lord,
But that date is not given.
24.
Page
2015.
24. This date is not given, so it relates back to the date when the death occurred. That time computer printout was not available.
No, at that point of time, it was not issued, my lord, it was later on. I am not saying that it was
Computer was there. In 1982, computer had come.
5.
At least in Guwahati, it was there, 1982.
During the time of Asian Games, television was first. During the time of Asian Games, television was first
No, even computer was there in 81.
in Assam.
81, 82, it was there in Guwahati.
Open bana. Fully map निकालो.
We can take it, it's not problem.
Let us see how the tribunal has examined it.
Page 33, that's good.
But you see, there's no point looking at the opinion of the tribunal. You have yourself disconnected yourself with your parents and father, disconnected with your grandfather in your cross-examination. Sharma, just for a minute, send back the record.
Yes, please.
At page 119, our mother statement is also there.
Is there any statement about the date of death of your father?
It is only in the my lord, at page 24, my lord, the death certificate. Page 24.
No, you're not on the certificate.
Statement.
He expired in 85.
Yes. She herself.
But then you don't have a case. Never before the date. Fifteen. 016. So this is what has happened in your evidence. Take a look, see. It. This is exhibit G, page 113.
My lord.
Exhibit J,
Yes.
113.
Yes.
Read that certificate. The petitioner was born on
1983, my lord.
1983. Look at the name of the father.
Ramzan Ali.
No, you don't write, don't read the first word. Late,
Date of birth, my lord.
late. In front of your father's name, there is a word late.
Late, yes, my lord.
So
Because
that
it
means
was-
83
No,
when
but
the
it
child
was-
was born, the father was already dead.
No, but it was issued in
We
2016.
don't
That is
know.
why,
You see, then you don't write late.
that is why they have made mistake, my lord.
No. Don't tell us that. Look at the top. What is it? Extract of record.
Original report of the birth.
As per our record. If it is as per their record, a living man cannot be written as dead.
Perhaps at that time.
We don't know. Perhaps it's something. Perhaps
Definitely,
it's
my lord.
permutation and combination. We
Definitely.
don't know.
Because this is the. No, my lord, we have done.
Common intelligence.
There is one issue in the results. This because this was elected. Copy. A digitally signed document. I understand like at that point in time, there was some confusion about this, like whether a certificate will be required under the IT Act or not. But that has been clarified later on, the digitally signed documents.
Yeah.
You don't need the certificate. Except if there are some contentions raised, really doubted. But usually digitally signed ones, do. Had it been a simple printout, then it's a different thing.
No. I don't, I think not. I think voter list are not exhibited. These are NRC documents also.
You have to do it open to 19. You should be saying we have a petition of this. No, this evidence is not there. That is like 98 no. These were never exhibited.
Yes, no.
No, that is why I'm saying, my lord, matter may be remanded back when opportunity may be given so that document.
Permit us to do so.
For the ends of justice, my lord can do it, my lord. Because there is a question of the my lord, fundamental rights, my lord, there. That is why my lord can do. Under 226, my lord has the power, my lord.
The authority says so. That's why. Somehow they tell us one authority at least, I think, federal institution, we don't have the authority. Yes.
Because my lord, see, my lord, because she has the document, but that has to be placed, my lord, properly before the tribunal. That is the main problem, my lord.
But part of the case, you could have progressed with the documents were not exhibited. You don't start in that. Maybe ask this question, I not from the record, then the document you were exhibited. This is for instance,
Will it not amount to a suppression of material facts? The not telling us about the unexhibited document forming a part of the writ petition. Is it not suppression of material facts? Third, Mr. A. Hari, learned counsel of the petitioner, also heard so and so for the respondents. By filing this writ petition under Article 226 of the Constitution of India, the petitioner, namely so and so, has assailed the opinion dated 25/5/2022, page 33, passed by so and so in so and so, thereby declaring the petitioner to be a foreigner of post 1925, post 1971 stream. Next paragraph. On receipt of the notice of the proceedings, the petitioner appeared before the learned tribunal and filed her written statement, inter alia, stating that she was born at Deopani Tea Estate. Spelling would be Deopani Deopani Tea Estate in the year 1979, and had studied in Deopani Grant, A full stop, B full stop, M full stop, E full stop, school in the district of Sivsagar. And that her parents were permanent residents and his father was permanent worker of Deopani Tea Estate under Geleki police station and was affiliated to Assam Cha Mazdoor, CHA, Cha Mazdoor Sangh. Post. She was married to Muhammad Ali Hussain of Teloi, PELOI, next word Bari, PERI, block, under Moran police station in the district of Dibrugarh, and started to live at the matrimonial home and was enrolled as a voter under Moran constituency. Next. In support of her defense, the petitioner had examined herself as DW1. And she had also examined her mother, Srimati Malijan Begum, as DW2. While reiterating the statements made in the written statement, the petitioner, in her examination in chief, stated that her father was Ramjan Ali, an employee of Deobani Tea Estate, and her father's name is recorded in the official record of Deobani Tea Estate. And on attaining majority, the name of his father was enrolled in the voters list of 1970 of 108 number Nazira, LAC. Her grandfather was Rosna, ROSNA, Rosna Ali, who had landed property in his name at village Nopam, NOPAL, Panoti, PANOTI, in the district of Sibsagar. And his father had paid the land revenue on behalf of her grandfather for the year 1970-71. On 31/1/1971, her mother is Maijan, MAIJAN, Maijan Begum, whose name was entered in the voters list of 1970 of 108 number Nazira LAC. She was born and brought up at Diopani Tea Estate and studied in the school referred above, from where she read up to class 7. 7 is Roman 7. And on attaining majority, she was married to Muhammad Ali Hussein of Hiloi Bari. Hiloi Bari, HILOI, Hiloi Bari block, the district of Dibrugarh. Where she's presently residing. And after marriage, her name was enrolled in the voters list of Hiloi Bari block under Moran constituency. And the concerned electoral registration officer had issued a voter ID card in her name. She has a PAN card and her mother was stated to be alive. She was stated that she had 2 brothers and sisters. Including herself and Muhammad Rahman Ali. They also stated that a FT case was instituted against her husband, but not against her parents, uncle, auntie, brothers, etc. She had denied that she came into Assam from the specified territory after 25 June 1971. She has 3 children out of the wedlock. She had exhibited the following documents. Page 34. Exhibit A to Exhibit J. Exhibit A. Full stop. Next, in our cross examination. It would be relevant to fact herein below the statements made by the petitioner during our cross examination. This is page 102 to 104 of PCR. Next paragraph. The projected mother of the petitioner, namely Srimati Madina MALINA Begum, was examined as TW3, had reiterated the statements made by the petitioner in respect of the petitioner being her daughter and the husband being working at Deopan Tea Estate. And that the petitioner had studied in the school referred above. She had exhibited her identity card as exhibit K. So voter identity, different voter identity card is exhibit K. So for petitioner, it is only the J. K is by DW2. In a cross examination, she had stated that she had appeared before the tribunal on the request of the petitioner. She had not filed any document to prove her linkage with Marina Begum. She denied that the petitioner was not born in Deopan Tea Estate. Petitioner or her father was born at Deopan Tea Estate. He denied that the petitioner had never studied in the school referred above, or that exhibit K is a false document. She had also denied that the petitioner is not a foreign national, or that she had imposed falsely in the court. Next paragraph. The next tribunal peruse the readings and the evidence on record. You were finding that exhibit J was not proved by the issuing authority. And was not admissible in evidence. So exhibit A and exhibit B were discussed and discarded on the ground that those were only computer generated copy. not accompanied by any certificate of the concerned authority and not admissible in evidence. So exhibit C was discarded as land revenue paid receipt does not determine the Indian nationality of the father of the petitioner. This was exhibit D. E and F. The same were discarded as the issuing authority had not approved the documents. And also DEF. Please to believe. EDC. H I K. Birth certificate. Exhibited the same. Exhibit HINK. It is discarded as those were documents not issued before 1971 or between 1966 and 1971. And accordingly, it was held that the petitioner cannot prove that depending on those documents, the petitioner could not prove that that she was an Indian citizen. Accordingly, the opinion was issued in favor of the reference and against the petitioner, holding her to be a foreigner of post 25 in 1971. No, post 1971. Next. The learned counsel for the petitioner had submitted that though the petitioner had documents to connect her to her projected parents and grandfather from her, but the proceedings was not appropriately conducted by the before the Foreigners Tribunal. In this regard, the learned counsel of the petitioner is referred to the electoral roll of 1970. Project that the voters list of the year 1970 disclosed the presence of the father of the petitioner. In the certified copy of electoral roll of the year 1970 of village Deopani in the district of Sibsagar. By referring to the land revenue paid receipt format is submitted that the same was issued on 31/1/1971, which was prior to the cutoff date of 25/3/1971. Discloses the presence of the father of the petitioner in this state of Assam. Which are the other documents you say is prior to 1971?
Left is 21, my lord. Her mother list, my lord.
He also, the learned counsel for the petitioner also relies on the NRC disclosing the voting year on 1970, the name of the father of the petitioner, namely Ramzan. Sorry, Maijan.
Mother,
M-A-I-K-A-N,
Maijan.
Maijan, my wife of Ramjan. Accordingly, comment is submitted that as the petitioner did not bring the issuing authorities of several exhibits to prove the document or the certified copy of the voter list 1970 containing the name of the father and mother of the petitioner. This is a fit and proper case for remanding the matter back to the learned tribunal to give, by giving an opportunity to the petitioner to prove those documents in accordance with. So it is submitted that the Factor Board have power under Article 226 of the Constitution of India to issue such directions for the ends of this, as the fundamental right of the petitioner has been curtailed. Next one. The contrast for the done it standing counsel for the FP matters as compared to the cross examination of DW1 and DW2. Submit that the petitioner has not been able to make out any case for interference with the pure opinion. Insofar as power of the court under certiorari jurisdiction is concerned. If this is reliance on the case of
Central Research Council.
okay. That's Central Research versus Bikatan Das. Which lays down the law relating to the extent of interference which can be done in by the High Court. Which limits interference only when there is a error apparent on the face of record or if the finding of the tribunal is perverse. It is submitted that there's no cases made out by the petitioner. No interference of the opinion is called for. Next one.
Central Council for Ayurvedic Sciences and other purposes, Bikatan Das and others.
Yes, he has it. My
Civil appeal number
prior secretary has that.
999 of 2023.
Next one. Yes, examine the records of the learned tribunal. And consider the submissions made at the bar. And also examine the case law cited by the learned standing counsel for the FP matters. Good stuff. At the outset, the court is constrained to not consider having examined the PCR must take note of the fact that the document which has been marked as exhibit J is a birth certificate issued by the Deopani Tea State Hospital on 13/8/2016 by which it has been certified that the information contained therein has been taken from the original record of birth, which is registered at the hospital of the Opani Tea Estate. Full stop. In the said certificate, it is stated that Miss Malina Begum was born on stated to the effect that the petitioner, that the petitioner is Malina Begum, was born on 20/12/1983 at the Opani Tea Estate Hospital, and her mother is Miss Maijan, Maijan, Maijan Begum, and father is late Ramjan Ali. Full stop. Therefore, as per the said document, on the date of birth of the petitioner, her father had already expired. The father had already died. Full stop. In her cross-examination, the petitioner has stated that at the time of death of her father, she was a girl of 8 years of age. Full stop. Therefore, the oral evidence appears to be contrary to contents of Exhibit J. Full stop. However, contents of annexure 6 to the petition is in bracket page 24. There is a certificate by the manager of Deopani Tea Estate stating that late Ramzan Ali had expired on 21/12/1985. 1985.
As per date register.
As per the death register. Therefore, so however, they said that the death certificate has not been proved. By the petitioner regarding the date of death of father. Thus, the contents of exhibit J puts to doubt the fact as to whether the father of the petitioner was alive at the time of birth of the petitioner. So the petitioner had left the Deopani Grant KBME school on 31/12/1992. However, father's name is not shown as a deceased person. Rather, the name of the father is mentioned as Muhammad MD, Ramjan ROMJN Ali. Be that as it may. In view of the admission made by the petitioner in a cross-examination, that almost all the exhibited documents submitted by her were issued after 1971, except exhibit C. And except exhibit C, there is no document in the name of her father and grandfather. And in view of the admission made by the prosecuted mother of the petitioner in her cross-examination, that he has not filed any document to prove her linkage with the petitioner. What is the considered opinion that from the exhibited documents read with the cross-examination of DW 1 and 2. The petitioner has failed to prove a link to her projected father, projected parents, and the projected grandfather. Next, in so the submissions of the petitioner that the matter can be remanded back by allowing the petitioner to use of fresh evidence. Fresh written statement and evidence. In view of the ratio laid down in the case of Sharkan Das, Vijay Jagat Chopra, as the court does not find any perversity in the opinion of the learned tribunal, in as much as the learned tribunal has not failed to take notice of any readings or documents, and that the learned tribunal has not passed the opinion based on any materials, extraneous materials or unexhibited documents. It is not a case where the petitioner had desired to prove, had desired and taken steps to prove exhibit A, B, E, F, G, and J in accordance with law, which was refused by the learned tribunal. Notice is made out to remand the matter to enable the petitioner fresh opportunity to exhibit those documents. Next, accordingly, repetition, the challenge for the Indian opinion fails and the repetition is dismissed. Which of the consequences of the opinion would follow. Next. Registry shall send back the records to the concerned learned tribunal along with a copy of the order to be made a part of record. If you can convince us even before we rise, immediate, before we rise for the day, if you can show us any document that matter can be remanded back, we'll still.
And the tribunal has
Before
passed, my
tribunal-
lord, judgment and order, my lord. That can only opinion, maybe. It can pass only opinion, my lord. That cannot pass judgment, my lord.
That is okay.
She has the document, my lord, can remand it.
That's okay, but that's why we are telling you, since you are making that submission, we give you an opportunity before the rising.
For the interest of
court.
justice, my lord, she has.
That's why we are giving you an opportunity. Before rising of the day, if you can show some authority, we may still, before signing, we may revisit the order. We'll take a short break and come back.
Item 3.
May I approve the also.
Yes.
Purposes in order, pages 67. Whereas I was declared as a foreigner, though I submitted the 15 documents, but only what's that we did not prove the authority with the same documents files.
Mr. Sharma, in this case, you'll have to go through the records. There are few cell deeds of earlier years. And one of his brothers were declared to be a foreigner,
Indian,
not a foreigner.
Indian.
Go through the records. We'll admit it for hearing. In the meantime, you go through it. And please also examine if that record is required to be called for.
Yes, sir.
Let's go through it.
Same documents, same view. It will have, you can have to declare yourself, Indian we declare yourself, same photo. So document same. Document same. Executive three documents, this will be. This or get 60, 70, 70 documents, 3, 4. 8, 70, 60, 0, 2. From 0, 5, project, agree upon good trade. Any concerned projects, before 68, similar. Thousand documents is written.
Yeah, next question.
Okay.
Transfer file action.
If you are an
Oh, you did not give evidence. You did not give evidence.
already given. Two witnesses are already examined. Page 45. Cross portion is for page 55. My sister was examined DW2, is page 58.
No, that earlier opinion of your brother is not exhibited.
Already exhibited. my lord.
Where is that exhibit number?
Exhibit 10. Exhibit 10.
Where is the document? Which page?
This original record. my lord. Certified copy is with me. Certified copy is with me. But it an original record is there.
Pass it on. Where is your written statement? Which
Resume
page?
23 page.
Where is the reference to your brother? Muhammad Jalaluddin, where is his name in your written statement?
I introduced statement, para 11, answering opposite party respondent Bilaluddin saying that the real actual fact is, my brother's name is mentioned in there, in para number 11. And answering opposite party is respondent saying that he will.
Read that part. The Jalaluddin name is where?
Pardon, my lord.
Please read that part where the name of Jalaluddin is there.
Page 28, the answering opposite party respondent is saying that the one separate proceeding was initiated against the present opposite party younger brother, Muhammad Jalaluddin,
Page- page-
page 28. Para 22. Jalaluddin invites FT case number 73-2015. However, the younger brother of the opposite parties contested the proceedings by filing written statement, adduced both oral and documentary evidence, and exhibited some original documents. After appraisal of the documents and evidence adduced by the said opposite party Jalaluddin, younger brother of the present opposite party, and also exhibited the same documents which are exhibited in this case, and the Honorable Tribunal member of number 3 give his opinion on 23/2/18 that the opposite party Mohammad Jalaluddin, Mohammad Hasanuddin of the Gerwa Gaon under Khatwal police stations, Nagaon Assam is not a foreigner who had not entered into Indian illegal between 1966 to 24 to 71. Twenty-one page. Although the father about the application of other than which was decided in his favor, is no case against the other member. 73 pages. 71, sorry, 71 page.
Fully mentioned.
71 or says mention, yes, 72 and 50. Discussion of message. So.
Okay. Okay. Yes, okay. Mm.
54, 60, 68, 77. Original salary posted.
Yes. একদম ক্লিয়ার ডিক্লেয়ার করছে কিন্তু কিন্তু এগুলি ডিসকাস করা কোন ডকুমেন্ট হইবে একটু তাই ফটো জমাইছে কি ডিরেক্টলি তো দেখুই তো এনএক্সআর কি নাম ছিল করো পর্যন্ত
Annex and other.
হ্যাঁ এনএক্স করা নাই
Code record. Exhibit 10. Is that, sorry.
রেজিস্টার করা নাই নাকি
গমেই না কোথায় করবো। করলে হেঁটে গেলে ভালো হবে। Yes, definitely.
এর থেকে এরকম সময় থাকতে হবে
My lord. Yeah.
You collect your, this copy from the court master tomorrow. We'll pass orders in chambers, Lord. We propose to send it back.
Yes, Lord.
Is there anything, Mr. Fine?
Probably, my lord, one thing your lordship may kindly see. The brother opinion. The learned tribunal has relied on the documents probably, that is land documents which is possessed by
It
the,
doesn't rely on anything.
no, earlier, in earlier, other case.
Huh.
In other case.
Same
my lord,
document.
Yes, one thing in page 72 of the, my lord, the opinion. The, her brother Mohammed Bilaluddin is the legal heir of late Hassanuddin. That is their father, and now possess the land property which were purchased by their father during his lifetime. My lord, because the opinion is not here, earlier opinion.
It is there, you are sending
Yeah,
it back.
yes.
You see the record.
So, my lord, so
You see, where is the discussion? You see the opinion, where is the discussion? No discussion of any exhibit, no discussion of pleading. It merely says the petitioner was there till before COVID. After that, he's not there. 4 years it is pending, so I'm disposing it off and dispose it off.
there is another issue, my lord, because my learned friend also. And the matter was earlier ex parte declaration.
No, it's okay,
Yes.
not ex parte.
No, earlier it was ex parte.
No, you
They-
forget all those
Yes,
parts.
then,
Now the evidence is that there's an evidence and there is cross-examination.
yes,
After that, what should the tribunal do?
you should discuss everything. then.
Discuss everything.
Should have passed the order on merits.
Yes.
From what you are saying, can we ask you something more? Do you need that we make an observation in the order that the home department will consider whether training is to be given?
Your lordship may dispose of then in that line
What
only. my
happens to the training? Once you say,
Nothing.
once you say these people have to be trained in art of judgment writing, order writing, opinion writing.
lord. On that line, your lordship, the materials available on record. That you will discuss.
Yeah. This order doesn't agree to us. This exposes the. The have a table. Not taking cover of reading. The evidence was not one inch. You see, there is something more. So you have to opinion use.
Yes, ma'am.
Look at the opinion, the concept, one is not.
Who is named, sir? OP. Yes.
See about 165 page. The city page is one.
Yes, ma'am.
Okay, one. It's not only cross-examination is not there. Still, there is by not discussing. Traveling will state a lot of things for the state government. Some award for. It's just award.
There been more should have been more careful because already there is an order. I mean, opinion.
Yes. After the evidence, it says expired. My lord, that's not that is the problem, my lord, what the tribunal has done. Probably they misunderstood the direction of this noble code. The earlier direction of this noble code. This noble code demanded, after she was, after filing of the evidence, when she was absent for long. And yes, she would have she was have considered the evidence which is filed. She could have passed the order. Examine the, yes, really think over. But it takes away artificial time. Yes. Examine and talk about it.
May I submit these documents? Highly reasonable.
Item 4 for admission.
May it please your lordship, this class about the matter for time being met.
Item 5 for admission.
Lordship, kindly matter will be passed over for the time being. Item number 5 and item number 6. Yes.
Supplementary item 16 for orders.
বিদেশী ক'ব নহয় য়েছ তেতিয়াহে ক'ব মই চাবমিট কৰিম নহয় তুমি ক'ব যে মোক এটা কপি লাগে তেতিয়াহে তুমি চাই পেলাই পিছত আহিব পাৰ্মিশ্যন দিলে মই দি দিম টেষ্ট কৰোঁ ক'ব নহয় আই উইল গো থ্ৰু দিছ ভেৰি ইম্পৰ্টেণ্ট February, but February. হিয়াৰিং টেষ্ট নকৰিব, বেলেগ দিনত কৰিব, তেতিয়া নাহে। মানে ইণ্টাৰমিডিয়েটটো হিয়াৰিঙত আহি আৰু সেইটো ক'ব পাৰা। হা হিয়াৰিং টেষ্ট কৰি দিয়ক, ইণ্ডিপেণ্ডেণ্ট মই তোমাক এটা কাটি দিম। তুমি চাব লাগিব না, নহ'লে কেনেকৈ জানিবা। সেইখিনি ক'বা কিন্তু মই এইটো চাব লাগিব। হিয়াৰিঙতে বেছি পৰে। এইটো তেখেতক দিওঁ, মোক সেইটো লৈ আহ। এইটো নহয়, এইটো বেলেগ। 23 ছেপ্টেম্বৰত ইয়াৰে নেকি? ইয়াৰে হয়। এইটো হয়, কণ্টিনিউ হয়। চাব লাগে বুলি তোমাক। Lawsuits.
But apart from the, but the medical, there is no. Without. The reference to the. Optional will take into for medical examiner. It says that the. Vehicle will be registered process. And if the other vehicle.
Hello,
Then the.
that's directed to produce Ministerial inquiry report earlier. Ministerial inquiry report is there, my lord. Dated 20th September 2025. Ministerial inquiry. There is a ministerial inquiry report. You are also directed to.
As per your case is that number one, the people intercepted, tried to hit the police person. But second, you say that the police person was after entering the entrance, he was hit. And then after biting the hand of the person, and
Naveen job, the
it's not there.
Same date, it can be able to.
Yes. Lots of noticed. Let's see good idea. So next Monday, sometime in the day. Four.
This is covered only.
No, next Monday, two. Yes, two. Second February. Second February. Monday.
Yes.
Hard or hard?
Mr. P. Sharma, an additional senior government advocate for the state, has produced a copy of written instructions dated 5/1/2026, along with certain enclosures thereto. We note that though the police personnel accompanying the missing person was sent for medical examination, but the medical examination report is not enclosed with the said communication. Next para, accordingly, the learned senior government advocate prays for some time to produce the medical examination report. Stop. Placed again on 3/2/2026.
Well, the next item, I have got a fixed matter at 2 in other court. I prefer taking up after some time, my lord. Not at 2, after the matter is over. I'll come back.
Yes.
Item number
17, my lord. Supply 17.
17. Yes.
17.
Okay.
Not at 2, after some matter. Lordship.
Judgment. Item 1, WBC 4200/2025.
গোটেইখিনি একেলগে কৰিম এই তিনটা একেলগে আহিব
Delivery of judgment, item 1, 2, and 3.
Item 1, 2, and 3, opinion dated 30/4/2021 in FT case number 112, 115, and 114, and order dated 15/2/2024 in review petition number 135, 134, 136 are all set aside. The petitioners are directed to appear after their bail. Bail is given to them. They are in Motia, so bail is given to them. After their bail, they are directed to appear.
Before the tribunal.
Yes, and contest the proceedings.
Yes.
And the other
Four.
petition also same order.
Item 4.
Item 4, same order.
God bless.
In 4 they will review, but since they come from the state family, they are independent.
Yes, yes.
Time being item 4 for admission.
Please, your lordship. The opinion is at page 90, madam. Trial court record was called for minor, that was received. Madam.
Which is the best document you have to connect you to your projected parents?
My lord, it is the my lord Jama Bundi, my lord, at page 81
81.
of the there, my
That
lord,
is
and
its exhibit number
exhibit number, my lord, G. I have annexed it as a page 81, man. Yeah, Assamese version at page 82, my lord. This is a Jama Bundi of Ali government. Ancestral landman. But his name is shown as instead of Nurul Islam, my lord, instead of Nur Islam. The other brothers' name are there, my lord. At page 82.
What is your name?
Name is, my lord, Nur Islam, but here is showing as Nurul Islam, along with his brother's name, Nur Muhammad, who is also DW2, my lord, Jabbor Ali, and Ambia Khatun. Ambia Khatun, their sister, my lord. May I read, my lord?
Just a moment.
In typing, my lord, there is only mistake. Nur Islam is there, Nurul, my lord. Number 4 is Nurul Islam.
But if you are showing us page 81, 82, then your relationship with your projected father is not established. We'll show you why. Come to page 30.
Yes, my lord.
You've seen that page 30?
Yes, my lord.
Last, there was a plot of land,
Yes.
so and so.
Yes.
In the second part is own name with brothers and sisters as ancestral property.
Yes.
Correct?
Yes, my lord.
Come to page 41. This is your written statement. Page 41, this is your evidence or affidavit.
Yes, my lord.
Certified copy of Java Mandir. Same thing, repeated here.
Yes, my lord.
Correct?
Mm.
Now the document you are showing at page 80 and 81 is not ancestral property being mutated. This is conversion of land from so and so.
External to my lord, Mia Dilam.
So if it's a conversion, that means it's a land which you have got it on your own account. Your ancestry is lost here.
Besides
But
this,
Mr. Pai, this requires some hearing. We admit it and put it up for hearing. We give him bail for the time being. He has not been granted bail. But this is item 4. But Mr. N. Sarkar and counsel for the petitioner. And also for the respondents. Para 2 of the last order. Pursuant to order dated 12/12/2025, over the records of the tribunal is received. The court proposes to examine the records. In the meantime, issue rule returnable forthwith without requiring any first step to be taken. As all the respondents are represented, next paragraph. List the matter for hearing on in the week commencing 16/2/2026. Next paragraph. The prayer for bail is opposed by the Government Standing Council for the FT matters. Considering the position made in the application, then it is time to take bail out of this 5,000 to the satisfaction of. So training of the list order, Rosali.
obliged.
Time being item 5 for admission.
My lord, in this case, my lord, LCR was called for and same is received. Uh, My lord, today I pray for bail, my lord, and matter may be fixed for hearing interim prayer.
The best document you are having?
My lord, petitioner's father casted vote in 1966 and 71, page number 11 and 18, my lord.
Link documents.
13.
Link documents. How you how you examine your shifting? You relied on panchayat certificate only.
Panchayat certificate and Gabura certificate, that page number 28, my lord.
How does this page 28 document prove your case?
Page 20, my lord.
20.
My lord.
28.
My lord, I could not understand, my lord.
Which page do you want us to see? Page?
My lord, so far shifting, my lord.
No, you wanted us to see a document. Which page?
My lord, page number 28, this is the Gabura certificate.
28.
28.
How
This-
does this 28 prove your case?
My lord, this is the Gabura certificate linkage with her husband, my lord. That is not relevant, my lord. The relevant, my lord, is that, my lord. Page number 26 and 27, my lord. Link with the father, my lord. Was a photo of 1966, my lord. Page 26.
26. 26 of PAN card.
26, wherein the, my lord, the father's name is there, my lord.
Oh, this is post 71 document. There was something which can prove your link with your father.
My lord, thereafter, page 27, father's name is there, my lord, sponsor certificate.
PAN card is relevant for you as a counsel.
My
If
lord.
you have the PAN card of the client, it is good enough. Not for us.
Page 27 is the secretary of Panchayat, my lord. Father's name is there, my lord.
Again, this does not prove your case. You see, your case in your written statement is that in after 1966, your father shifted. Correct?
My lord.
After 66, your father shifted. Now, page 27 says, so and so was a resident of so and so has now shifted, now migrated from the said village to the above mentioned locality by virtue of a marriage. That means this does not prove your father's shifting, it proves your shifting after marriage.
My lord, shifting of father, my lord, this is one part. Another part is my lord, shifting of the petitioner with her husband. That is paragraph 11 of page 37. Father shifted, my lord. Her husband also shifted from the resident, my lord.
And this document has a disclaimer, circle officer certificate at page 27 is only for the purpose of NRC, legacy data. It's not a proof of citizenship.
Her cousin brother was examined, my lord.
Why cousin brother?
My lord, the cousin brother is 52.
Why cousin brother?
My
Why
lord,
not
he
your
was
own brothers?
one of the witness, my lord. He came to the tribunal, my lord, to prove, my lord.
Where is your written statement? We wanted to see your the father's date of death,
It
year of death,
is 35, my lord.
35. What is the year of death of your father? I think we have a question. Just give me, let's see. I think like it. Mr. Pang, this notice was issued to the tribunal through email. They have not responded.
Well,
Give them 10 days more times.
Yes,
Since Mr. Ali is praying for bail, you have to take it up early. Where is the cross-examination of DW1?
my lord, cross-examination, we could not obtain the certificate copy, my lord. I have enacted the SIP, my lord, only.
We require that. Also, the representative is seen that despite service of requisition for the tribunal's records by email dated 17/12/2025, the records have not been received by the concerned section. Accordingly, let a fresh reminder be issued by email. Reminder for record be sent by email to the following email address of the said tribunal, next para. We open trust that the superintendent of the tribunal shall take necessary steps to send the record. Of FT fourth case number. Last order para 2. So and so. And so and so. Is I don't know 30/10/2024. Next para respond. Give a date after 10 days.
Tenth of February.
10th of February. 10th of February, before that you say, the learned counsel for the petitioner shall be at liberty to renew the prayer for bail on receipt of the records of the tribunal.
Time being item 6 for admission.
My lord.
This is separate, I'm not taking it.
My lord, in this case, my lord, the petitioner's father, my lord, casted vote in 1966, and the petitioner casted
You have to satisfy us why
link, my lord.
this was ex parte, why you did not.
My lord, ex parte page number in the impugned judgment, my lord, page
2023.
37.
And it is 2023 opinion.
Yes,
Why you are, what
My
is
lord,
the explanation of delay?
petitioner was totally not aware, my lord, because the notice was served upon the wife, my lord. He was not aware. He was at Karnataka, my lord. Page number 37. Last 5 lines may be seen, my lord, as per report of the process, my lord. 5th line from the bottom, my lord.
Which page or paragraph is the statement for explaining the delay?
My lord, para 6, page number 6, my lord.
This is with regard to the notice. My lord, with regard to the notice, he has said, my lord, that notice was though served upon the wife. But this opinion was passed on 20/06/2023. Why he has not come immediately thereafter, that is not explained anywhere. Delay of laches of filing of this writ petition is not delay. Laches of filing of this writ petition is not disclosed. This is only on expertise, my lord, how expertise open. And secondly, my lord, if it is an expertise opinion, there is a provision of law, provision in the law that he can file a review petition in the tribunal. Yes, that's why, my lord. Within 60 days, he has to file. Within 30 days, yes.
No, there is no statement also when he has got to know about the.
Yes,
agreement.
that is statement is not, that is the point, my lord, which I'm raising. That there is no statement at all, how he has come to know, why he has preferred this writ petition after, my lord, delay of 2 years.
And no whereabouts also, where he was
Yes, yes,
working,
it is
when,
also.
nothing. Mr. Ali, no statement.
My lord, actually, my lord, the real fact I have explained, my lord. Actually, there is a separation, not judicial, but in fact, there is a separation with the wife, my lord, who could not communicate. And his wife also did not understood about the notice, what to do, my lord. So, my lord, this is a real fact that, my lord, he was not aware, my lord, actually. My lord, some opportunity may be given, my lord, he will prove, because he casted vote with his father, who is a voter in 1966. So one opportunity may be given to explain before the tribunal, my lord. Various link documents is there before your lordship, my lord. So I pray, my lord, just only one and final opportunity.
Where did you go? He's no information.
My lord, for his livelihood, he went away to Karnataka. my
Traveling,
lord.
you go by train, you go by flight. You don't give the particulars of your travel, when, where did you travel, when did you come back?
Really, that should have been given. So after lordship may, my lord, one opportunity, final opportunity may only 30 days time may be given, my lord.
Particular.
My lord, if, my lord, then my lord, I will file an additional affidavit, my lord, explaining all, my lord, because some.
What is that? Why? Why did you not get the person? How is the manufacturer story?
No, my lord, my lord.
But I had to fly to US, had to go to California, and came back. So, go to Colorado. I had to come to California.
Humble prayer is that, my lord, the documents may be examined maybe with the tribunal, my lord. That much, my lord, one opportunity may be given, my lord.
But in fact, with regard to the notice also, 5C, 35C, my lord,
Any other member.
any other members.
That is.
So, yes. So she's an adult member of the house, my lord.
Who received the notice, she did not communicate, my lord.
Item 17, for orders.
All right, lordship.
Your lordship, lordship. Lordship. Yeah, lordship.
Item 7 for hearing.
May it please, my lords. My lords, in this matter, before going into the merits of the case, there is some jurisdictional issue. There are two petitioners, OP1 and OP2. OP1 is the son, Mr. Samad, and 2 is the father, Abdul Mazid. So here, if we go by the reference from the judgment, I'm just showing two paragraphs, the opinion. That is at page number 77, the last annexure. So if my lords see the first paragraph, the SPB Nagaon referred this case to the Foreigners Tribunal Nagaon for adjudication, as the allegation is that OPs, namely MD Abu Samad, alias Abdul Samad, son of Abdul Mazid, alias Mazid, alias A Mazid. Number 2, Abdul Mazid, alias Mazid, alias. So father and son, residents of village Behaguri, so and so in the district of Morigao, have illegally entered into India between the period of 66 to 71. So this is something which I want to show, my lord, that the reference was from 66 to 71. And I have got some judgments, and lordships already knows that it cannot travel beyond the reference. So what was finally decided was that we have entered after 71. So that was the decision. That is one. And second, more surprising thing is that OP number 2, against OP number 2, there is no reference at all. Not even of the category of 66 to 71. No reference at all. So to my humble understanding, my lords, there is no inherent jurisdiction of the Foreigners Tribunal. It is only when a reference is made, and to the extent of the reference. And there is a third jurisdictional point, and why it may also be called as perverse. The order, if my lords come to page 80, in page 80, the paragraph 6. And therefore, in my considered opinion, the contesting OPs are illegal migrants having entered Indian territory after 25/3/71. And they are therefore declared foreigners under section 2A of the Foreigners Act. And as OPs are declared foreigners, all other blood related immediate relatives are deemed to be foreigners. Now, whether this can be done, because there are judgments against this also of this honorable court, deemed foreigners. So these 3 points I wanted to highlight before my lords, before going any further. And my lords, I may give some judgments also. Copy or was it? Order selling.
Yes. It's Abu Samad.
Petitioner one.
That is this. That is. It's a bit like a base. Because these were IMDT references. IMDT, in fact, there was no distinction between six or reference is only against one of the summer. That is it. So even though it is kind of the lordship can see you should write the Abu Samadan. Other your lordship definitely was set aside. It's the liberties there with the SP construction. Otherwise, your lordship has to see whether the opinion against Abu Samad is valid. That must other the other PW additional number 2.
Samad is the son. The OP2 is the father. So his
it's
decision was based on OP2.
Yes, but I'm not on that matter. Whether it is of OP number 2, matter that is the petitioner number 2.
Oh.
Your lordship may dispute the matter. Yes, consequence, whatever consequence, if it's not there, there is no matter. Is there also, there should be a matter present when. However, your lordship has to see whether the opinion against Abu Samad is carried on.
Yes, sir, we will do. The next piece and for this reference? No.
This Lukia Begum portfolio, madam. Lukia Begum. It's 2279 of 2021.
You have the case with you?
Yes.
Just read out how it was, what it was handling there.
Just in fact, the records of the paragraph. Yes. Era 15 by.
Hmm,
My lord, I have also gone through the judgment, the paragraph cited by the learned counsel on the other side. So what I understand is that there are two parallel judgments. One says that it cannot travel beyond the reference, which I have provided, and which the other counsel from the other side has provided, which says that it has to be understood as both. So, Lordship, I am, in my very humble opinion, I'm not an expert of judicial discipline, but if there are two bench of equal strength, so maybe a reference to a larger bench, if this issue is, if there are conflicting issues, so that I leave to my lord. Because which I have also given, that is very clear, cannot travel beyond reference. 16. Rules কিন্তু একরকম। Rules গুলো এখানে। Rules গুলো হয়, কিন্তু একটা হয়। Uh, Now, whether Lordship is asking for petitioner 1 or 2? Okay. If it is 1, then Lordship, I would come to page 39. Here both petitioner 2 at the first, Abdul Mazid, and Samad, his name is at serial 4, the 4th serial. So this is Samad connected to Mazid, petitioner 2. And before that, of course, the other, I could not provide certified copy at that time, but 37 also, page 37 also Lordship can see from photocopy I have taken. This is 1985. This is when for the first time my name had appeared. Petitioner 1's name had appeared. Page 37. And this has also to be read and compared with page 34, where my father's name is there. Petitioner 2's name is there. So since not 34. 34 to 87. No, this is 75. I'm sorry, Lordship, that is 75. That is before 10 years before. So there, yeah, because yes, that was not executed. So, Lordship, so far as exhibited document is concerned, if we see how they were appreciated, we had given 1966 voter list. That is that was Exhibit A. And Exhibit A is in that is page 29. This was Exhibit A before the tribunal. Yes. My father and grandfather, they were there in 1966. Where Lordship? 89. So, 39. Okay. Lordship. Lordship is had talked about Asan Ali. Asan Ali. Grandfather's name in 89, Asan Ali. That is all. Same person. Hassan and Asan. Yes. Obvious. Obvious.
Yeah. Order. It's like. I'm trying to get it.
Time being item 17, WP criminal 19/25.
Day after tomorrow.